Hello, everyone, and welcome to the LexisNexis webinar titled Construction Law Updates, COVID Restrictions, Adjudication, and New Home Warranties. We'll be jumping into today's presentation very shortly after the following housekeeping. If you're having trouble with your connection at any point, the best solution we can suggest is to log out of Zoom and simply log back in. In any case, a recording of this webinar will be made publicly available and circulated to the attendees after it is complete. The webinar is accredited for 1.5 hours of substantive CPD credits, and we have reserved some time at the end of the presentation for audience Q&A. You can submit your questions by clicking the Q&A button at the bottom of the screen, and I will read them out to the panelists at the end of the presentation. We'd also like to draw your attention to a sample of some of the construction law resources available on LexisNexis's Quick Law and Practical Guidance platforms. You'll see those on your screen at the moment. The first such resource is an online text called Bidding and Tendering, What is the Law? It's the 6th edition. It's authored in part by Glaile Bulls LLP, and incidentally, we have a construction lawyer from Glaile Bulls on our panel today. Another text includes the newly updated 2021 Annotated Building Code Act by municipal law experts John Mascaron and Jeffrey Levitt. And lastly, please feel free to take a look at our practical guidance platform for the LexisNexis Construction Lean End-to-End Toolkit. And with that, let's introduce our panel. Anne Hatzios is a member of Pallet Vallow's construction and commercial litigation practice. She has a wide range of experience before all levels of court, having represented builders, developers, and trades in matters before the Construction Lien Court, Superior Court of Justice, and Ontario Court of Appeal. She has received advanced training in mediation and brings a practical business-focused sensibility to her practice, honed during her pre-legal corporate experience. Leona Kung is an associate lawyer at Koski Minsky LLP. She has a civil litigation practice that specializes in construction and commercial litigation. Leona regularly handles a variety of construction-related matters involving liens, construction contracts, breach of trust, bonds, delay, and deficiency claims. She has acted for clients at all levels of the construction pyramid and has appeared before all levels of court in Ontario. She is also called to the bar in New York. Dan Fridmar is a litigator and an academic who serves all aspects of the construction industry in Ontario. Dan operates his own practice specializing in construction law as well as litigation, negotiation, and client management. In addition to his legal endeavors, Dan has spearheaded many academic initiatives, including authorship of legal blogs and articles, presenting at various professional development lectures for clients, and acting as a content producer and course designer for the Credit Institute of Canada. Ivan Marrow is a construction lawyer at Glaile Bulls LLP. He represents clients at every level of the construction supply chain. Ivan most frequently acts in disputes involving contracts, liens, trusts, bonds, delay claims, deficiencies, and professional negligence. He has appeared at all levels of court in Ontario and in insolvency proceedings under the BIA and the CCAA. He's also acted in ad hoc arbitrations arising from large-scale infrastructure projects. In addition to his law degree, Ivan holds an MBA degree from Queen's University. And last but not least, Christine Kellowan is an associate lawyer at Goldman Sloan Nash and Haber LLP, practicing civil litigation with an emphasis on construction and new home warranty matters. She is a practice group leader at the New Home Warranty Tarion practice group at her firm, and Christine represents various actors in the construction industry. She has appeared at all levels of court in Ontario and the Builders Arbitration Forum. Christine has taught the construction law course at George Brown College, and in 2020, she was a recipient of the Toronto Construction Association's Sean P. McKenna Young Construction Leaders Award. With that, let's dive right into our first question to Christine. Christine, the administration of the Ontario New Home Builders Registration and Licensing is being taken over from Tarion by the Home Construction Regulatory Authority. What changes should lawyers who are accustomed to the Tarion processes and issues be prepared for, and what should they know about the change overall?
Thanks, Timon, and thank you, LexisNexis, for inviting me to today's panel. So anyone dealing in this sphere, they know that pre-February 1st, they were dealing exclusively with Tarion as it related to everything from licensing, the warranty claim process, dealing with arbitrations at the Builder Arbitration Forum. After February 1st, what has happened is that you now have HCRA, or the Home Construction Regulatory Authority, which is taking over the licensing side of this particular area. So they're going to be dealing with the conduct of the builders. They're going to be investigating any illegal building of new homes in Ontario. They're also going to be dealing with builder competency. Another key difference here would be that they'll be now managing something called the Ontario Builder Directory. And essentially, this was, if you went on Tarion's website before February 1st, you could have typed in any builder or vendor's name and would have had a listing of the number of home possessions, claims against a builder, etc. What's now happened is that that information has been migrated from Tarion's website onto HCRA's. And the key difference here is the information that is now available to the public for builders and vendors is actually more, I dare say, invasive, because it says more information about the nature of monetary claims against vendors and builders. So that's sort of the splitting of the division of powers. Tarion will continue to deal with the warranty process. So essentially, that's sort of the breakdown. There's a lot of different changes that have occurred. I won't go through all of them, but just in terms of like the key changes that I've also seen is there's going to be new fee schedules. So now, for example, they're going to be charging a regulatory oversight fee for every home that's being enrolled. Anyone familiar in this area knows that every agreement of purchase and sale must have the Tarion addendum, which is essentially is just a schedule to the agreement of purchase and sale. So that addendum has also been updated. There's no more they call it a homeowner information package, which essentially, as the name suggests, when a homeowner would take possession of a home, they would get this information package on, this is the home that you've purchased. So that's been done away with, and now all that information is available on Tarion's website at a learning hub. And very lastly, a new key development, and this was actually implemented last year, but it's also crucial, is that there's something called a warranty information sheet, which must be attached to every agreement of purchase and sale. And this warranty information sheet, it's really just designed towards consumer protection. So essentially saying you have these various warranties, these are the exclusions to the warranties, and this is a process for making a claim.
Okay, thank you very much, Christine. And there's a follow-up question for you here. What are the COVID-19 impacts on new home construction Tarion procedures? For example, what delay notice obligations are triggered by work stoppages or shortages? This isn't necessarily with respect to the change from Tarion to HCRA, but just overall, any COVID-19 impacts that our lawyers should look out for.
Right. So as I mentioned a few moments ago, every agreement of purchase and sale must have this Tarion addendum that's attached to it. And this addendum provides a certain procedure for allowing a builder to extend the time for providing occupancy to a homeowner. And in this procedure, it's called the unavoidable delay procedure, okay? And essentially, an unavoidable delay, it includes things such as, if there's fires, if there's something such as a pandemic, anything that, well, not anything, but it's really an enumerated list of, I wouldn't dare say force majeure, but it's an enumerated list of events that would be impacting the construction of a home. So in terms of, these delay notices that you would give under the unavoidable delay provisions of the addendum, essentially what vendors and builders should be doing is within 20 days of an unavoidable delay happening, they're supposed to be sending these notices out to their purchasers and advising that, the occupancy of their home is going to be delayed owing to this unavoidable delay. And so, the buzzword here is the pandemic. And most people would assume that because we've had this emergency, we had our first emergency order since last March, that, somehow all of the builders and vendors in Ontario would have the same time frame for claiming an unavoidable delay. And that's not actually the way how Terron is treating these unavoidable delays, because it's really dependent on the stage of construction. So, for example, with our latest lockdown, a new home could have been already built and just in the finishing stages. And then the question becomes, is the most latest lockdown really impacting the delivery of the home? So in those circumstances, it would be inappropriate for you to send an unavoidable delay notice. Whereas for another builder where, if they're starting to pour the foundation and because of the lockdown, they're experiencing supplier delays, etc., in those circumstances, it may be advisable for them to send out their first notice. So once you send out your first notice, there's a second notice that has to be sent out. And this second notice is sent out when your unavoidable delay, i.e. the pandemic, is about to, it's concluded. And so in this notice, what you would say to your purchaser, this is the period of delay, and on top of that, I need another additional time frame to remobilize and get back onto site. Now, it's very crucial that both notices must be sent out, and they must be sent out strictly in accordance with the terms in the Terron addendum. Because if you don't, the builder or vendor essentially is opening themselves up to delayed closing compensation claims. So the bottom line here is there's two notices, and it's important that they're sent out not only on time, but in accordance with the requirements of the addendum.
Okay, thank you very much. And with that, we'll shift over to Leona. The question is, could you provide us with a summary of what's important to take away from the updated lien practice procedures in Ontario?
Yeah, absolutely. Thanks, Timon, and thanks, LexisNexis, for having me today as well. Obviously, in March of last year, COVID really disrupted a lot of our lives. And, the courts were heavily affected as well. And in, I think it was March 15th of 2020, the Ontario Superior Court of Justice had suspended all operations, save for urgent matters. And shortly thereafter, the Ontario government issued an emergency order, if you recall, declaring a state of emergency. And under that, there was also a regulation that was issued that suspended all limitation periods and any procedural time periods that were required under any proceeding or any intended proceeding. And this took effect in, I think it was March 16th in 2020. And when that came out, a lot of people, and I'm sure all the panelists here included, had a quick knee-jerk reaction to what this meant for construction liens. Because potentially this meant that construction lien time periods, in terms of having to preserve and perfect your construction lien, were also suspended. And obviously this had significant implications for the payment of holdback on projects, because if your lien time period was pushed out, that meant that payors couldn't safely, and owners couldn't safely pay out holdback payment. So as a result of this issue, I think it was really potentially an oversight. The Attorney General on April 9th issued a letter to say that the emergency order and that regulation suspending time periods would be amended to state that all time provisions under the Construction Act would not be affected by the suspension starting April 16th. So really what this meant was that as of April 16th, construction lien time periods, you didn't have to worry about any suspension. If you have a lien, you continue to preserve it by whether it's a given lien or registration on title. If you needed to perfect your lien, you had to do so in accordance with the time periods provided under the Construction Act, and whether that was the 45 days under the old act or the 60 days to preserve under the new act. And then you had 90 days from your triggering event to preserve under the new act, and then under the old act, and 150 days under the new act. So that all continued to apply, even though under the emergency order, the suspension of limitation periods was continuing on until September 14th of 2020. So all of that really is to say that in the construction world, since COVID hit last year, things continue to move forward so that holdback payments could be made properly and not being withheld because of this suspension. So there's potentially a total suspension of time period of about 30 days under this emergency order. And really, when at our office, and I'm sure all construction lawyers are doing this, when we speak to our clients, we advise them to treat as though there is no suspension, to act as if there is no suspension on time periods, and everybody continued to lien, to perfect their liens, and to set their actions down for trial in accordance with whatever time period under the act is required, and act as if there has been no suspension. And that's really the best way forward, because under the Construction Act, as we all know, if you miss a time period, it could be very detrimental to your lien rights. And because of that, in terms of lien practice procedures, the Ontario court had to really quickly adapt and be able to offer remote hearing of motions to vacate liens, because obviously if parties are continuing to lien projects pursuant to their timelines under the Construction Act, the mechanism for vacating liens needed to also be in place. With the courts being closed to in-person attendance, the lien court in Toronto really quickly moved to come out with a set of procedures to allow for hearing vacating motions in writing. And so our construction lien masters here in Toronto came out with a set of procedures really quickly and sent it out via the various organizations to let everybody know that they were continuing to do business as usual, and that liens were being vacated, albeit being heard in writing. And we were able to obtain those orders and submit it to the accountant's office and have security posted into court in order to ensure that projects can continue running smoothly and the liens could be vacated. And since then, so that was all done back in April of 2020. Since then, courts have now moved quite quickly, really, to hearing various motions, pre-trial matters virtually. So I think starting last July or August, I was already able to obtain an attendance virtually to have a pre-trial set and heard in a lien action, which is great news for everybody in the construction industry, because obviously things move really quickly. And if you have payment being held up, you want to be able to get a court date, get your liens vacated, move your action forward. And this is all in line with the Government of Ontario's order revoking the suspension of time period limitations for time periods under the Construction Act. So good news all around. We're sort of back to usual business in a sense since April, although under a new normal. But that's where we're at right now, Timon.
Thank you very much, Leona. And we'll continue that discussion here with Anne as well, expanding it outside of Ontario. But before we do, there's potentially a bit of a looming question. It's a bit of a speculation, but Is there a likelihood in going through the oscillation, the existing lockdown, that there could be another restriction on any limitation period? And then a follow-up question to that is, can you compare the effects COVID-19 has had on lien procedures in some other Canadian jurisdictions as well?
Well, Leona's gone through the practice in Ontario very thoroughly and certainly cautioned us very, very well. I'm going to go through the suspension orders in other jurisdictions in a faster way, but just to get an idea, because sometimes we are dealing with clients who are who are retained on projects across the province, and it's interesting to see how the Ontario regulations line up with some of the situations in other jurisdictions. So starting in Quebec, Ministerial Order 2020-4251 was passed on March 15. And it suspends or extends prescription periods, which are what we know as limitations periods, forfeiture periods, which are mandatory statutory timelines, and procedural deadlines, which are the ones that relate to the rules of the court. And that was for non-urgent matters. As in Ontario, the court continued to hear anything related to urgent family matters and COVID-related issues. So the applicable suspension period was March 15 to September 1, 2020, which is a period of 170 days. However, there's a question as to whether or not that suspension is valid in dealing with construction liens, or what in Quebec is called the legal hypothèque. Under Quebec case law, a lien period is a forfeiture period. However, the authority under which the ministerial order was passed, Article 27 of the Civil Code of Quebec, doesn't permit the minister authority to impact forfeiture periods. So, as Leona suggested, it's best to proceed out of an abundance of caution if you're dealing with Quebec matters, and simply rely on the fact that that suspension period does not impact your timelines, because there is a possibility that the order may be invalidated moving forward. So, going to the other end of the country, British Columbia, Ministerial Order M086 suspended limitations periods to commence court proceedings effective March 26, 2020. And it applied to any mandatory limitation period and any other mandatory time period established in an enactment or law of BC within which a civil or family action proceeding, claim, or appeal was required to be commenced. It was repealed and replaced on April 15, 2020 by a subsequent ministerial order. That revision specifically allowed that the suspension does not apply to any mandatory limitation period or any other mandatory time period established under the Builders Lien Act or Division 5 of the Strata Property Act, which also concerns builders' liens. So that language, the mandatory time period, suggests a broader application than what we're dealing with in Ontario. But again, without judicial determination as to how that language should be interpreted and how it impacts, actions under the Act, it's difficult to tell how it's going to impact, liens that, let's say, were preserved, accounting for the suspension. So the applicable suspension period in BC was from March 26 to April 15, 2020, which is a period of 20 days. It's also important to keep in mind that BC has another kind of lien that attaches to the holdback, not the property interest, which is the traditional lien that we see in Ontario. Those liens are subject to the regular civil limitation guidelines. They're called Shimco liens, and they arise out of a case called Shimco Metal Erectors and Design Steel Constructors. For a Shimco lien to be preserved, the contractor must commence a claim with the court at any time before the holdback is distributed. So even though the timeline is dependent on the civil limitations period, because it ties to the distribution of the holdback, there still is the potential that the lifting of the suspension period will impact when people can preserve those rights. In Alberta, a ministerial order suspended the timelines from March 17 to June 1, 2020. It affected limitations periods and procedural timelines. And the order includes an appendix that specifically deals with which statutes and regulations the suspension does not apply to. So unlike the situation in Ontario, where we were confused initially in terms of what the impact of the suspension would be on liens, in Alberta, the order specifically excluded the limitations, the appendix specifically included the Limitations Act, but excluded the Builders Lien Act. So right away, people knew that there was no impact to the lien deadlines, and you would have to proceed as if everything was proceeding as normal. In New Brunswick, there was a state of emergency ordered on March 19, 2020. A suspension was imposed on the same day and applied to any act, regulation, rule, municipal bylaw, or ministerial order that established time periods for taking steps in any proceeding before a court, administrative tribunal, or other decision maker. The order has been renewed and revised a number of times since then, with the latest revision having taken place on February 12, 2021. The subsequent revisions to the order specifically provided that the suspension period for limitations periods under the Mechanics Lien Act resumed running on July 31st. So in New Brunswick, the suspension period was from March 19 to July 30, 2020, being a period of 133 days. Under New Brunswick procedure, there's a 30-day timeline for filing a claim for lien with the registrar. Then a court action is to be started to enforce the lien. So the language of the suspension order, which refers to commencing a proceeding or taking a step in a proceeding, would seem to apply to the court action to enforce the lien. But the timeline for registering the claim for lien appears to be unaffected. So in that case, and again, absent any guidance in terms of how these timelines are to be interpreted, again, acting out of an abundance of caution and continuing to proceed in the same way that you would normally would be prudent. In Newfoundland and Labrador, there was a notice to the profession and general public regarding COVID-19 preventative measures that was issued March 19, 2020. It suspended the filing deadlines for all non-urgent matters, meaning anything that wasn't related to public health and safety, COVID-19, or urgent family matters. The timelines under the rules of the Supreme Court were extended by general order dated August 4, 2020. That order provided that any periods that were to expire from March 18 to August 23, 2020 were extended to August 24, 2020. But the suspension applies only for those timelines under the rules of the Supreme Court, not the Mechanics Lien Act. So the timelines for liens are unaffected. In the Yukon territories, under the Civil Emergency Measures Act, no limitations periods under Yukon law for bringing a civil or family action, appeal, or proceeding in a court expires during the state of emergency or during the 30-day period immediately after the state of emergency. The state of emergency has been extended by the latest extension. It was extended by 90 days starting December 7 and is to expire on March 7, 2021. But the suspension doesn't apply to the rules of the court. So looking at the construction lien procedures, there's no guidance as to whether the time periods for liens under the Builders Lien Act is affected. And again, it comes down to the language of the order. Because there's specific language within the Lien Act, it really remains to be seen as to whether or not it will apply. The Yukon order specifically distinguishes between limitations periods and rules of the court. So there's at least some suggestion that different types of timelines are going to be interpreted in different ways. In Saskatchewan, Manitoba, Nova Scotia, Prince Edward Island, Northwest Territories, and Nunavut, there have been no suspensions issued. So considering the likelihood of whether time periods are going to be suspended again, there's no guidance really in terms of this. We're all just kind of, going along as things happen. But my sense is that given the fact that the courts were inundated with so many matters once the suspension periods were lifted in the jurisdictions that imposed them, I think that it's likely that as much as possible, they're going to try to ensure that things can continue as normal. But it's important to consider, and especially, when we look at the Construction Lien Act, the whole purpose of this area of law is to ensure that the small guys are protected in situations where you have owners and large-scale GCs that have a larger amount of power on a project than, let's say, a trade or a subcontractor. And so it's going to be interesting to see, as these matters go before the court, how the court uses that aspect of it to interpret the wording of the suspension orders to ensure that they can continue to protect the interests of the smaller players.
Thank you, Anne, for that insight from across the country. Much appreciated. Talking about timelines, moving to Dan. This next question is on delays. COVID has repeatedly affected supply chains, and lockdown measures will likely exacerbate backlogs and an unavailability of certain materials. When a particular material isn't available and waiting for it to become available would cause inordinate delay, what issues should lawyers for contractors anticipate and be prepared to respond to?
Thanks, Timon. In principle, there are three main issues that I've identified that are crucial, especially when it comes from a subcontractor, contractor to material supply delay. And the first one is mitigation of harm. So the idea in any of these sort of backlogs and delays is that while there is an industry-wide issue with certain materials being unavailable, lawyers should still advise and guide their clients to ensure that if litigation is to take place, they have to think about the cost and assess of damages that could possibly arise. So, for example, where a lawsuit arises as a result of parties causing delays or being unable to obtain materials on time, it may be worth lawyers working with their clients to explore whether it may be cheaper in the long run to either obtain materials from another source rather than incur those litigation expenses. And then obviously another point of mitigation then becomes the sort of damage that could be caused to relationships. Many contractors, it's not the first project they're working on with their owners. And so it may, once again, in the longer interest of things, be better for contractors to look out and see what sort of other sources they can obtain, whether it's at a higher cost, whether it's not from Canada, it's from other sources, but ensuring that the project can move on so that they can maintain those relationships. And especially one thing that I've noticed is that where those relationships are exacerbated by COVID, where there's issues of supply or there's issue of not being able to complete something on time, those trades and those contractors that are able to pull through and provide the material when it's necessary, I think that'll go a really long way once we're out of COVID, so that where you have requests for proposals or where you have certain bigger and better projects coming along, even though it may cost a little more right now, the fact that they were able to do that at this stage will really go a long way. Another aspect is practical issues. So insofar as actual delays are concerned, there are methods of moving around scheduling on construction projects so that even if, let's say, one thing can't be done, there may still be other work that goes on so that the entire project is not delayed. And with that in mind, one thing that I would suggest to lawyers is to work with their clients in working with and developing scheduling software. So for example, there's software such as Procore, Primavera, Oracle, which allows general contractors and owners or construction managers to plan out really what's going on step by step on these projects. And by coming together with other trades, with other aspects of the job that needs to be done, it's possible where there are inabilities to bring forth supply, or there's inability for certain work to be done, to at least work together in ensuring that there's not extreme delay on the project. Another thing to assess, once again, and speaking just in the cost of litigation, is understanding whether or not certain work on the project is subject to per diem, so daily delay costs. And all of that then becomes a mathematical and cost efficiency question of how much is it worth spending more on, being able to acquire certain materials, as opposed to necessarily going in with acquiring them somewhere else. And similarly, with that in mind, and just the idea of coordination really becomes important here. As counsel, whether you're in-house counsel, whether you're a lawyer helping with early litigation stages, it's very important to see if you can coordinate with parties on the project. I think one big industry-wide feeling that's come out of this is that there is amicability and there's a willingness to work together and cooperate, just because everyone's sort of in the same boat when it comes to these issues. And so definitely encourage your clients to have frank and open discussions with other trades, with project managers, see if there's a way to keep the work going, and to really facilitate construction project as a living organism. The final issue that you may want to consider now is this idea of renegotiating contracts. And this became present as early as March of last year, where everyone all of a sudden realized now you need to have force majeure contract clauses in place. Otherwise, there are issues that can't be met that otherwise don't qualify for contractual protection. Another contractual provision that I found is very useful for especially subcontractors and material suppliers to have is substitution provisions. So the idea where you have a clause in your contracts that allows for a substitution of a specific material if, let's say, that initial material isn't part of the quote, or wouldn't necessarily be considered an extra. And a perfect example of this, whoever of our listeners are part of the framing or carpentry industry are well aware of the shortage of pressure-treated lumber in North America that happened this past summer. And so one thing that I noticed came about is that a lot of people, instead of relying on pressure-treated lumber, were trying to renegotiate to allow for other materials, such as, for example, cross-laminated timber or any sort of other substituted material, so that the projects could keep on going. And I think it's very important to have these sort of clauses moving forward because they do allow to help result-based discussions to be facilitated. So, and for example, if these clauses exist, they can either discuss, either a renegotiation on that specific part, whether it becomes an issue of price, whether it becomes an issue of the extent of which replacements can be made. And obviously, one other thing that council should keep in mind is that it's important to have these sort of discussions and considerations early on, where, let's say, a project has already been started and you can't necessarily renegotiate the contract. It is important to perhaps bring a change order or a site instruction or directive to see whether or not any sort of delay or delay caused by lack of material can be reduced by way of substitution.
Okay, thank you for that, and thank you for the insight on the pressure treated timber. Appreciate that. The next question is to Leona. If a general contractor learns of a subcontractor that has been diagnosed with COVID-19, what are the extent of their legal obligations? Furthermore, what are not simply legal obligations, but are considered industry best practices? And I guess subcontractor using here as an example, but this could apply for anybody on site.
Yeah, that's an interesting question, Timon, because in Ontario, both constructors and employers have a duty under the Occupational Health and Safety Act to protect workers from workplace hazards and various dangers. And although although a general contractor may not necessarily be the employer of the workers that are employed by a subcontractor, a general contractor will typically be assigned the responsibility of workplace safety over the particular construction job site based on the OHSA, and also a lot of times under the prime contract, there may be some sort of clause in there that says the general contractor is responsible for the construction job site. So in that sense, currently under the Ontario guidelines, the constructor and the employers have to ensure that there is a policy, there are policies and measures in place to protect all workers from COVID-19 and ensure those policies are being trained, the employees and workers are being trained on those policies. And these safety measures are, we've heard them time and time over again now, but, making sure that work areas are sanitized. If you've got another crew coming in, making sure in between those areas are cleaned up and sanitized with this disinfectant, making sure tools are also sanitized if they're being used by multiple people. A policy may also include how illnesses are to be reported to whether it's the GC or the sub, the employer of the subcontractor, and thereafter reported to the GC. This might also obviously include PPE and physical distancing, ensuring that there's a 2-meter distancing between workers on site. And another important thing that's being discussed is air ventilation and airflow. So on a construction site, the reason why there's been some sort of mixed information about what type of sites can proceed and not proceed, if a lot of times there are construction work sites may be outdoors, and that might assist with air ventilation, airflow, which, as we know, is a good thing for the current pandemic. Another thing that employers and the constructor will need to do is also screening the people coming to work site. And we've all seen the list of questionnaires that restaurants and stores and everywhere have been employed, and that's really important to do. Make sure you're asking your employers, your workers, whether they've been outside of the country, they've come into close contact with anybody who has tested positive for COVID-19, whether they're experiencing any of those symptoms. Anecdotally, I will also say that some issues that have arisen on work sites include, if one worker overhears another talking about, say, a party they went to over the weekend, what can and what should an employer do about that? Because if one of your workers may not be adhering to some of the safety measures or they're recommended by public health outside of the workplace, what can you do? Well, there is obviously under OHSA, as I've said, a duty to ensure the work site is safe, right? So I would say in those circumstances, the employer may wish to politely ask the worker to not come to work until they've quarantined for a certain amount of days or something like that. And that's something that these policies will have to be developed by the constructor and make sure they're in place and make sure their workers are being trained as to what to do and to ensure workplace safety. I will also add that anecdotally, I've heard the Ministry of Labor will come cracking down on whether it is an employment location, whether it's a construction site. The Ministry of Labor is sending out their inspectors to ensure that these safety measures are being adhered to and that the employers do have some sort of safety measure policy and guidelines in place. And in fact, I think one client had indicated that they feel like the Ministry of Labor personnel are really one of the workers now because they come on site so often and they ask everybody to make sure that they know how to wash their hands and they're ensuring that everybody is being brought through the proper protocols of hand washing. So that's the Ontario Health and Safety Act. And those are some of the legal obligations that an employer or constructor will have under that act. Separately in Toronto, you may have heard that in January, the Toronto Public Health also issued further requirements on employers. And although this is specific to employers, I would argue that that would apply to a general contractor as the constructor of the site, and definitely with respect to its own employees, but potentially with respect to any workers employed by subcontractors as well. But under these guidelines, employers are now, they need to immediately notify Toronto Public Health where 2 or more people connected to the workplace premises test positive for COVID-19 within a 14-day interval. So when this occurs, the employer must provide contact information for these people and ensure the person is readily available to communicate with Toronto Public Health to implement any additional measures. So Toronto Public Health will be responsible, and other local health units will be responsible for contacting close contacts. And they'll get that information from the personnel who have tested positive to ensure they get the contact information of close contacts and contact them. The employer is also to notify the Ministry of Labor immediately of these positive cases, and also to cooperate with further infection prevention and control measures to ensure that the workplace continues to be safe. And this includes maybe not allowing entry to workers while the place is being inspected and disinfected and sanitized. So those are some of the legal obligations that the employers and constructors have. Obviously, after you put in a policy in place, you want to make sure that your employees are also abiding to some of these safety measures and guidelines that the public health units are recommending outside of the workplace safety, because as we know, this illness is transmitted via people and via communicating and being in close contact with people. So, I mean, obviously, as an employer, you can't control what your employees do outside of the workplace, but there is an element to it that if you are able to understand that, ask that your employees also abide by these guidelines and ensure that they understand that is to protect the workplace safety. That would probably help the work site itself as well.
Okay, thank you very much, Leona. And in the spirit of more just general business advice as well, this question goes to Anne. What business advice and support can lawyers provide their contractor clients while business is suspended, including non-construction specific advice such as temporary layoffs and other business activities they continue, such as taking the opportunity to follow up on their contracts and procurement processes while construction is suspended? Oh, and you're on mute.
It's going to take a while till I actually get the knack of this. Building on what Leona and Dan said, like the scope of what Timon is asking is far too broad to really deal with. So I've focused really on some of the issues that have come up specifically within my practice, the type of business issues, labor issues, and contract issues that I've seen throughout the pandemic. So with any type of legal advice that we're giving, really we're dealing with the circumstances of the client, the business, and the situation that they're in. So it's difficult in this case to really talk about anything in broad strokes. But there seem to be two areas, distilling all of the areas that Timon just raised. There seem to be two key issues that have come up. The first is delay, and the next is cost. So before getting into specific issues, I want to touch a little bit on the broader context that Leona spoke about. In every respect, the circumstances brought on by COVID-19 are unprecedented. And we know that word is being overused in terms of describing this, but in the context that we're talking about, it is really important that there is no precedent for how to deal with these matters, because in many respects, we are providing legal advice that's prefaced by saying, well, It's possible, it's likely this might happen because we don't know how this is all going to play out. So the fact that we're in this unprecedented situation can have significant repercussions on contractors and other actors in the construction industry. Generally, construction contracts and any kind of contracts that we're dealing with within the industry, it does not contemplate pandemics. And that's a big problem when you're talking about how to deal with these issues that are arising. So consider the situation of a typical trade. The project is put on hold because of an emergency order. Then when they can finally get on site, they can't have the same number of workers because there are distance requirements. They have to supply PPE and whatever other measures, Leona went through in terms of what's required. Materials costs have gone up, or as Dan suggested, materials are just unavailable. And, it's a key factor. CERB is paying out in what is an equivalent wage in some cases to what people would be paid to actually be on site and doing work. So there's a delay to the schedule from the shutdown and the slower pace of work, plus whatever costs are associated with that delay. And then there are the expenses for PPE, materials, and paying workers a premium so that they actually show up. But again, all of this is unprecedented. So the contract doesn't provide who's going to be responsible for these types of things. So looking at the question of delay, let's consider the language of a CCDC2 stipulated price contract. Under general conditions 6.5.3, that's the force majeure clause. It accounts for things like strikes, fire, and adverse weather, and includes any kind of delay that's not the fault of the contractor. And on at first glance, this would seem appropriate for the pandemic. But the only relief allowed to a contractor under that provision is an extension to the contract time. So even if your client is party to a CCDC2 contract, which, unlike a lot of the contracts that we deal with, actually contemplates these types of, unanticipated situations, the only recourse is an extension to the contract time. So what we're talking about is really who is going to take responsibility for these acts of God, really. So when advising clients, the first thing to do is to take a look at the contract. Try to find which provisions would allow for an increase to the contract price and determine how they might apply to your contract and how you can make it fit to satisfy whatever it is whatever situation your client is facing, and how they would be able to make a claim to ensure that they're protected for these unexpected losses and delays. The second area that I want to look at is notice. So going back to the example of the CCDC2, GC 6.5.2 provides for delay resulting from a stop work order issued by a court or public authority. Now, reasonably, this would seem to apply to a situation where a project was locked down under a suspension order. But the section only allows for an extension of the contract time and payment of reasonable costs incurred as a result of the delay. And so when we're looking at that broad category of costs that contractors are incurring in association with the pandemic, there's a question as to whether or not they can be considered reasonable costs associated with the delay if the delay is applicable only to the period of lockdown. So whatever kind of contract you're dealing with, and in any situation, you want to look at the notice provisions, because the one thing that you want to ensure is that you protect your client's ability to make a claim. And in many cases, compliance is critical. And the manner by which notice is delivered is also important. If your client is facing problems on a site whether it be for delay, cost, labor shortages, which is a key issue, even with the Ministry of Colleges no longer certifying people to do specialized work. This is something that you want to make sure your client gives proper notice of. And, we know that in many cases, it's acceptable on construction sites for information to be communicated verbally, for texts to be sent, really long email chains to go back and forth. This is the kind of situation where you want to make sure that notice is obvious and that it is properly delivered. So even if the contract doesn't have specific notice provisions, what you want to do is formalize the issues that your client is having in notice in writing, make sure that a copy is delivered to the owner, general contractor, whoever the other party is, in hard copy, send a copy by fax or email, do anything you can to make sure that that gets into their hands. Because, like we said, it's unprecedented, and we really are waiting on the courts to make sense of how this is all going to play out. So tying back to what I said earlier, the whole scheme of construction litigation really has to do with protecting people protecting people from really losing out, or insert whatever word you want right there, due to these power imbalances. So you don't want to see the little guy bearing the brunt of the pandemic. And so taking appropriate steps to just kind of set the record at this point might assist moving forward. Okay, the next area that I'm going to look at is additional costs. So this is probably going to be the most common question that you're likely to get asked if you are dealing with clients, or if you're in-house counsel, the one that you're probably grappling with, most often at this time. When it comes to project costs during the pandemic, any concern on the part of your client is probably related to the difference between the actual costs being incurred in completing the project and the cost that was originally agreed to for the work. So, when we're looking at this situation, there are things if you're talking about a job that was, let's say, bid upon, 2 years ago, or a tendering process that took place a long time ago, the types of things that contractors are having to deal with right now were entirely unanticipated at that time. So, for example, under the CCDC2, General Condition 10.2.3 requires the contractor to comply with any rules or regulations that relate to the preservation of public health and to construction safety. So that entire list that Leona just went through of measures that have to be implemented on site, those need to be paid for, and someone's going to be out of pocket for them. Those are the types of things that would never have been anticipated by a contractor bidding on a job. So when you're advising your clients, or when you're dealing with your own contracts, you want to take a look at the provisions of the contract that allow for a change in contract price. So under the CCDC2, a contractor can make for a claim for an increase in the contract price if timely notice of writing is given to the owner and the consultant. So that ties back to, the notice provisions and making sure that things are accurately recorded and due notice is given to the other side. Under the CCDC2, on the commencement of the events giving rise to the claim, so on the commencement of the events at the beginning, the contractor must take all reasonable measures to mitigate the loss or expense and keep such records as may be necessary to support the claim. So you've got a contractor who, let's say, is coming to you now saying, I've incurred all these costs in association with the pandemic. What is the commencement of the event? Was it last March when the initial lockdown order came up? Is it the latest lockdown order that came up in January? What's the time period that you're going to be relying upon? And if you are setting a certain date, can that be considered timely notice? If under the CCDC 2, if it's a continuing event or if there's a series of events, one notice has to be delivered. And again, that's at the start. But accounts need to be submitted on an ongoing basis as needed by the consultant or the owner, and then a final account rendered at the end that shows the costs that are associated with that event. So this goes to the general advice that we give clients: record keeping invoices, timesheets, making sure that all those costs, all that time is directly related, in this case, to the pandemic. Because, we often end up with these issues with claims, and, the contractor, our clients will say, well, I incurred an extra $200,000. That's fine and good. Show me how that's directly related to exactly what happened in the pandemic. After that notice is given, a consultant has 30 days to provide their findings. And then if the owner or the contractor don't agree with those findings, then the dispute resolution provisions of the contract are triggered. So it's an important point to keep in mind, because what we're talking about when we start talking about dispute resolution is making a claim under the contract for compensation. It's a claim. So if you're dealing with a contract that does not provide for dispute resolution, you're really having a conversation with your client about the potential of legal proceedings. And consider how a legal claim would be brought if there is no contractual provision for an increase to the cost of work. So generally, with project costs, the contractor is essentially bidding upon the good nature of the owner. As Dan suggested, relationships are really important. And you're going to end up, in some cases, having an owner who's going to recognize that the situation is unjust, and they will try to help out. But we all deal with owners and consultants oftentimes, and we all are employed because of the fact that most people are not good guys. So in many cases, when you're talking about an increase to the cost of supplying under a contract, so setting aside the pandemic, so let's look at a situation as if everything were normal, and for example, there was an increase to the cost of steel.
Sorry, and just being sensitive to time, because we're at 2:03 right now, and I know we need to get to ODAC and prompt payment. Just flagging that for. But please continue.
Okay.
Yeah. It won't be a hard stop. I'm just saying. Yep.
You'll mute me. You'll just cut me right. Music plays, I'm gone. So I'll just wrap that point up. So, previous to the pandemic, when we were talking about an increase to the cost of doing work, that was considered a risk borne by the contractor. It was considered a cost of doing business. So moving forward, those are the types of things that you want to consider in terms of how to deal with contracts in the post-pandemic world. Who's going to bear the risk? How are increases to unanticipated costs going to be dealt with? And what are the provisions for delay? And as a final point, the one thing to consider is that where risk is allocated under a contract, there's a cost to that. And so when advising your client in terms of how to proceed when these additional costs are being incurred, you're going to want to consider, as Dan said, the relationships, but also whether or not, there are other factors that make it more prudent for them at this time to incur that cost of doing business and be able to move along. Thank you.
Thank you, Anne, very much. We're shifting gears a bit here to talk about the Ontario Dispute Adjudication for Construction Contracts, also known as, in short, ODAC. I'm turning this question over to Ivan. So for lawyers used to bringing the types of claims now within the concurrent jurisdiction of ODAC, what are some tips on the differences between a court claim and an ODAC claim? with the understanding, of course, that ODAC is still very young and just over a year old.
That's right. So thank you, Timon, and thank you for all of our speakers so far. I've been enjoying it. So getting into this really rapid fire, I wanted to focus on three key differences between an ODAC adjudication process and an ordinary lien action to primary remedies you might be looking at, whether you're an unpaid contractor or sub on site, or just litigation in general if you're an owner and having issues with some actors on your site. So the three key differences I'm focusing on are technical differences, speed and pacing, and then jurisdictional concerns, which might not ordinarily be present in a court action. Really broad-based technical differences. Adjudications are administered through ODAC's website. Law firms and legal service professionals will be looking at new training for their staff who are more used to traditional court processes. Contractors and subs can look at building in some in-house capability to handle some of these ODAC processes. It's intended to be a consumer-facing website that's fairly easy to operate, but there are technical legal elements to it that, in our view, still warrant an in-depth understanding of the Construction Act and whether or not adjudication is available in all circumstances. So what does that mean in terms of technical differences? Well, from a due process standpoint, there's no automatic right to an oral hearing, discoveries, or cross-examinations. Adjudication is intended to be quick and dirty. It is not an in-depth investigation at the level that a Toronto construction lien master or an Ontario judge is going to comb over a construction dispute. So it's going to be rapid fire. There are a few predetermined processes that adjudications are encouraged to proceed under. It's really the selected or appointed adjudicator's discretion how this adjudication proceeds. But what ODAC has done is suggested that certain disputes in monetary thresholds proceed in different ways, and three of those disputes are actually in writing only. So with ODAC, you're looking at potentially a very rapid, quick dispute resolution process that could, in theory, just be resolved in writing with the exchange of documents and written submissions. So from a strategy standpoint, it's going to favor parties who are organized, have supporting documentary backup, and when you're responding to adjudication, really your ability to quickly gather relevant information and respond to some of the points being raised may determine your likelihood of overall success in the process, because adjudicators are bound by deadlines by which they must release their determination under the Act. So when we talk about being rapid fire, speed is a major factor here. Adjudication is only available if the contract hasn't yet been completed. So it's meant to be interim in the middle of a project where a party can initiate adjudication under certain circumstances. After a claimant starts an adjudication, a clock starts ticking by which time ODAC can be forced to appoint an adjudicator if the claimant and the respondent are unable to agree. That once that deadline is over, as soon as the claimant sends their relevant documents to the adjudicator has a 30-day deadline to release a decision. They can apply to have that timing extended by a further 14 days. But really what we're looking at is a quasi-judicial process that from start to finish could be over in as few as 30, 35, 45 days, which compared to an ordinary lien action, that makes a lien action look absolutely glacial in comparison from a speed standpoint. The last point, I know we have a lot of lawyers in the audience. We're offering CPD substantive credits from the Law Society of Ontario for this session. I have to touch on jurisdiction, I think, as the last major difference. Before you fire up your ODAC account and start cracking off these notices of adjudication for clients, we as lawyers, and ideally clients, if you're considering doing this yourself, for the trades or contractors, you need to know that not every single dispute is subject to adjudication. I have a checklist that I use to go through some of these timeline evaluations. If you're interested in a copy or want to discuss further, reach out to me by email. But the first main date milestone point that we're looking at is, what was the date of the prime contract? Because many subcontractors will believe that the date of their contract matters for whether or not adjudication is available. That's not the case. It is the relevant governing contract is the contract between owner and GC. And there are complex fact patterns that make that question a little bit more difficult to detect. But long story short, we're looking at the contract date of the contract between the owner and the general contractor, and whether or not that was entered into on or after October the 1st, 2019. So that's why adjudication is new. It's recent, and some of these historical projects just simply won't qualify. Importantly, you also need to inquire whether or not there was a procurement process, because if there was a procurement process before entering into that contract, and that predated October the 1st, 2019, adjudication will not be available. So really, by procurement process, it's defined in the Act. It's an RFQ, request for qualifications, a request for proposals, a call for tenders. We don't have judicial definitions of what these terms mean for procurement processes just yet. That may come if parties go all the way and challenge some of these definitions in court. But that's number one. Know your prime contract date. Exercise your Section 39 remedy and your right to information under the Construction Act. Under Section 39, you are entitled to know the date by which the procurement process was commenced. Now, parties don't have to answer those Section 39 requests for 21 days. That may leave you short on time, but exercise those remedies. You have them available. They're often overlooked. And finally, I think that the main difference with adjudications is this limit on what you can actually argue for them. And that's defined in the Act. It has to do with valuation of services, holdback, notices of non-payment. There are specific enumerated disputes that are subject to adjudication. It's not everything under the sun. So we all need to keep that in mind. And when you're responding to an adjudication, keep in mind your jurisdiction arguments and have those available to shut down an adjudication if you think that they've gone outside of the scope of the Act.
Okay, thank you, Ivan. We'll continue our discussion on adjudication here with Leona as well. Leona, some adjudicators are legal professionals while others are not. They can be engineers, for example, or specialists in their field in construction. So what are the strategic considerations you anticipate in choosing between a lawyer, for example, a project manager, or an engineer to be your adjudicator?
Yeah, that's a great question, because there are about 60 or 70 adjudicators right now that have been certified by ODAC. So you do need to be an ODAC certified adjudicator in order to be able to adjudicate. And the ODAC will go through that process in certifying people. Once they get the application, you can submit an application. And typically you got to be at least 10 years in the construction industry. You're not an undischarged bankrupt, that sort of thing. And there's a list of those qualifications that you can find on ODAC's website. And in terms of choosing your adjudicator, that will really depend on the type of dispute that you have. As Ivan alluded to, this is a quick and dirty mechanism to resolve interim disputes during your project. So obviously you want somebody who will be able to look at your issue, and typically it's going to be some sort of discrete issue, and be able to understand the what's at stake, understand what's going on, and deliver a decision quite quickly. So some of the issues that could go to adjudication include obviously the notices of non-payment under the prompt payment regime. So if this is a problem of payment because maybe there's a valuation of materials supply or services supply, maybe you want somebody like a quantity surveyor as your adjudicator, because they can, adjudicators have the power to go on site and visit the project. So maybe they might look at it and say, I'm going to go on site, take a look. And as a QS, they'll be able to say, no, this is grossly inflated or not, or what is fair, and deliver a quick, dirty, interim binding decision so that all parties can move on. If the issue is a little bit more nuanced, has to do with the construction contract, for example, there's some sort of interpretation of a clause, for instance, that may require a lawyer looking at it. If it's talking about whether or not the dispute is over scope of work, for instance, is this item within this scope of work, or is it an extra? Do we need to interpret some plans and drawings? Then maybe you want an engineer or an architect or a PM to take a look at your dispute and adjudicate your dispute. And you might consider it what type of engineer. I mean, we only currently have about 60 or 70 adjudicators. And as you mentioned, there are either engineers, project managers, architects, and lawyers. But to the extent that you can find out if somebody is an electrical engineer or a mechanical engineer, that might be helpful as well, depending on the type of dispute you have. So that's something that you would want to consider if you are taking a matter to adjudication. And that's a discussion that I would highly encourage everybody to have with their lawyer when they're considering who to appoint or who to choose as an adjudicator. And if somehow the parties don't agree to the adjudicator, somehow that falls apart, then ODAC is responsible for appointing an adjudicator for the parties.
Okay, thank you very much. Bringing this back to this discussion on ODAC back to Ivan. Now we talked a little bit about the intersection between the court and the ODAC procedure. So ODAC decisions are confidential. So does that mean that the only source of case law that develops that guides these decision makers as to the law is the one that develops in court? And as a follow-up to that interaction with court, how is an adjudicator's decision enforced in court?
Thank you. So very simple to enforce an adjudicator's decision in court. I have one pulled up in front of me right now. Our firm was successful obtaining an adjudicator's order just this past year. It's a simple court filing over the counter. So the adjudicator's order is formatted in such a way, it looks very much like a court order. You visit the court, it's recognized and then can be enforceable. It's assigned its own court file number. So then you have your remedies essentially as a judgment creditor, and you can go after the person, with the ordinary remedies that you have available to enforce a court order. So that can be helpful. In terms of how we're going to build up some type of precedent for adjudications, it's going to be difficult. There's no question. These decisions are very much like private arbitrations. They're confidential. They won't be posted in the same way that License Appeal Tribunal, Tarion decisions, that Christine has been arguing for years now. They're not posted publicly like that. So really, we're going to be looking to the jurisprudence that's been built up under the Construction Act. There will be challenges to adjudicators' orders. There will be orders that exceed their jurisdiction. They may be challenged under limited appeal provisions, and hopefully we'll have the courts weighing in, beyond the narrow scope of the precise element that's being appealed. But I don't think that we can count on it. I think that we're going to have to still depend on our reported decisions. And maybe that will have to change in the future where, adjudicators' decisions will be published, or there'll be updates in terms of how these things are being interpreted, because otherwise adjudicators in some cases are going in very, very much blind and trying to, look at Construction Lien Act or Construction Act jurisprudence and apply them to a whole new regime. So that's still going to be something we're going to have to watch to see how that develops.
Okay, thank you very much. And this is a question for Dan. Can you describe your overall experiences using the prompt payment regime? What problems have arisen and what benefits have clients derived from the prompt payment regime? In practice, do you think it is working in the way it was intended to?
Thanks, Timon. There's one general idea with prompt payment that I've noticed, at least with my clients, and that idea is that there's still, unfortunately, a lack of education with it. I think partly it's because that prompt payment really only became applicable, as Ivan was discussing with interim adjudication, it only became applicable to contracts that were procured or entered into after October 1st, 2019. And unfortunately, because COVID hit in March 2020, we haven't really had too much time for that to really be a concern insofar as, what's on everyone's minds. We did have significant amount of education about prompt payment since about December 2017, when it really became streamlined and the act was royally proclaimed. But unfortunately, from what I've seen so far, is that there's still a lot of confusion insofar as I've seen in some instances subcontractors aren't getting paid on time, and so their material suppliers are reaching out to them asking about, well, where's prompt payment and I'm going to be getting paid, but they themselves haven't received the notice of non-payment, even though technically the timelines would have started to be triggered. That being said, I've also noticed in certain instances where I represent owners, and they have subcontractors reaching out to them trying to claim that, those are proper invoices, and that for whatever reason the contractor hasn't been responsive. So I think one general approach that I've noticed, at least, is that there really is a lot of confusion, and unfortunately there isn't too much guidance from the court. As of now, there is only one reported decision that relates to prompt payment, and that's with respect to a case that came out of mid 2020. It's called Court and Johnson. And basically what happened in that case is that a claimant tried to plead various provisions of prompt payment and failing to abide with prompt payment, but ultimately the court determined that that specific contract couldn't benefit from the regime because it didn't apply within the proper time period. And so I think, just as a one general piece of advice, both for counsel and for contractors and trades listening in, is, there's tons of resources online at this point. It is a relatively complicated area to understand, especially because it's still just being brought in, and parties are just realizing how it works and what to do. But definitely, as a general point, it's a great idea to educate yourself and understand, similarly to Ivan's checklist, whether or not your specific contract applies. I find that more often than not, the type of contracts that do technically qualify for prompt payment are the smaller home renovations that have started within the past year or so. Some of the bigger contracts that have been going on for a couple of years now, I see some subcontractors or finishing trades coming in and trying to rely on that when they don't really realize that prompt payment isn't quite applicable to them. I think one thing that is a good solution moving forward is that our CCDC contracts have been revised recently to reflect how prompt payment is going to be kicking in, and I think that's a good starting point, at least to bring in more as a transition into the industry. I think one thing that parties even outside of CCDC can start looking into now is with respect to what to add into their contract. So, for example, if you're an owner, consider including some form of procedure as to how or when proper invoices are submitted. If you're a contractor, include some form of clause about a clarification of proper invoice requirements, or the time period when an owner has to issue any dispute or any issue with the content or form of the proper invoice. And as a subcontractor, perhaps even including some form of provisions that talk about notification of payment receipt, which then also boils ultimately into the trust provisions that we have under the Construction Act. I think, just to leave this off on a note, I realize we have about 5 minutes left for Q&A, but I think in general, us as a practice right now, we really are excited for prompt payment. I have often clients reaching out to me asking about whether their specific instances will apply or not. But I think that by and large, we just need more time. With what had happened in COVID and the other sort of issues that we've been discussing today, there hasn't been too much light shone on prompt payment yet. And I think that if we have some more time, we'll see bigger issues and perhaps even bigger uses attributed to this prompt payment regime.
Thank you, Dan, very much. I notice we do have about 6 minutes left for Q&A, and I appreciate that the panelists have been answering Q&A as we go. So we'll try to squeeze a few more in here. I believe this one will be to Christine, but anybody else can pitch in here. The question is, can you clarify how the procedures and paperwork regarding builders and new home warranties differ if individuals own their land and contract to have a new home built?
So it really depends on whether the owner is going to be controlling the construction or if their builder is going to be the one that's controlling construction. So when I say controlling construction, if the owner is the one who, for example, they're selecting their trades, they're entering into the contract, they're the one making the decision there. In that circumstance, there's an argument to be made that it's an owner-built home, and the legislation provides that owner-built homes, if they meet all the conditions, doesn't actually have to be enrolled in the new home warranty process, because the idea is, if you build your own house, why would you have to warrant it to yourself? In comparison, if it's a situation where an owner, they own the piece of land and they hire a builder, and the builder is the one who's controlling the construction, the builder is making all the decisions. In that circumstance, typically I would say that the home would have to be enrolled in the Tarion warranty program. So again, like every circumstance is very fact specific. So again, like you would have to look at your particular circumstances.
Okay, thank you very much. There is an adjudication question here that's fairly in depth. I notice, Ivan, you've addressed it in part, but just for the benefit of the rest of the audience, the question is, when is a party obligated to undertake mandatory adjudication? For example, if there's a construction project with a chain of contract as follows: owner to GC to equipment supplier to manufacturer. The equipment supplier receives a notice from the general contractor that it is withholding payment due to delays, and the equipment supplier wishes to withhold payment from its manufacturer because the manufacturer was a true source of delay. Is the equipment supplier required to initiate mandatory adjudication within the time period prescribed under the Act? And if not, is this fatal? In other words, does that impose an obligation on the equipment supplier to pay the manufacturer? I know this is a long sort of fact scenario, so we won't hold you to it, but
it is, and I would invite anybody with a very specific fact scenario to reach out. I think that some things missing. We'd want to look at whether or not a proper invoice was delivered. We'd want to take a look at whether or not a notice of non-payment was formally delivered. We've already mentioned a couple situations where, folks at various stages of the construction pyramid have just not been compliant with the Act. So whether or not, your deadline to trigger mandatory adjudication is threatened, as long as we could fall under one of the other enumerated sections that you're entitled to adjudication, the real timeline cutoff that you want to be cognizant of is that the contract hasn't been completed, so that the project is still can be considered ongoing. That way, someone subject to fulfilling other requirements in the Act and us looking into it in more detail, generally, I think that a case could be made to still initiate adjudication. But again, this is a new process. We're learning about how this is going to be interpreted still all the time. My recommendation always to parties would be to keep in mind your concurrent lien remedies as well. Make sure that those deadlines are not expiring, because there is a fascination with adjudication as a new, high potential process. But in the meantime, lien deadlines, and that's why we focused on it quite a bit during this presentation, continue to run, expire, and once those are expired, they can't come back. So reach out to us, give us all the details. We'll have lots of questions and we can provide an answer that makes sense. And I made an offer to the individual who sent the question. So thank you for that level of detail. We might need another 90-minute session, and I might need Leona, Christine, Ann, and Dan to all weigh in on how they think that would shake out.
Okay, and with that, thank you very much, everyone, for joining us, and thank you very much to our panelists as well for the. We've covered a lot of topics. We've basically covered the entire construction industry from end to end in an hour and a half. I know there are likely some other questions that might come through, but as Ivan mentioned, I believe our panelists are open to receiving those and having the conversation go on further. as we can see in the chat, they're posting their email addresses there. Feel free to reach out. And again, thank you all for attending. We will have a recording of the session available shortly after. We just need to do some processing on it. But with that, everybody have a great weekend and enjoy.
Thank you, Timon.
Thanks, everyone.
Thank you, everybody.
Thank
Have a great
you.
day.
Take care.